Let me tell you something that surprised me the first time I truly understood it, something that took years of courtrooms, depositions, boardrooms, and brutal cross-examinations to fully appreciate. A lawyer's most dangerous weapon is not a statute, it is not a precedent, it is not even the truth, it is a sentence, a single, clean, deliberate sentence, placed at exactly the right moment, in exactly the right tone, with exactly the right word chosen from all the other words that could have filled that space, can move a jury, silence an adversary, shift a negotiation, or rewrite the conclusion an entire room had already settled on. I have watched it happen, I have made it happen, and I have seen what happens to those who do not understand this. They have the facts, they have the law, and they still lose because they cannot command the room with their words. This is what I want to give you today. Not legal theory, not courtroom dramatics, not a collection of Latin phrases to scatter through your sentences like confetti. What I want to give you is something far more powerful and far more transferable, the understanding of how language, when properly disciplined, becomes authority, how words, when carefully chosen, become influence, how speaking, when done with genuine purpose, becomes the single most important skill you will ever develop, regardless of whether you ever set foot in a courtroom. These 9 principles are not tips, they are not tricks. They are the architecture of powerful communication, built from the ground up by people whose professional survival depends on the quality of every sentence they construct. Master them, and you will never again speak into a room and wonder whether anyone truly listened. 1. The strength is in the sentence. Before anything else, before tone, before vocabulary, before the carefully timed pause, there is the sentence, the single unit of thought, the thing that must work before anything else can. Most people speak in fragments of thought, half-finished ideas launched into the air and left to find their own landing. They begin with one point, pivot to another, add a qualification, remember something they forgot to say earlier, and by the time they reach the end of the sentence, both they and their listener have lost the thread entirely. This is not a criticism. It is simply the result of not having been taught to think in clean, complete, deliberate units. Lawyers are taught this from their first year. Before you can argue, you must be able to state. Before you can persuade, you must be able to assert. An assertion requires a sentence that knows exactly what it is doing from its first word to its last. What does a strong sentence look like? It is not necessarily short, it is necessarily focused. It carries one idea developed fully, without detour and without apology. It does not hedge unnecessarily. It does not circle its own meaning. It arrives at its destination and stops. The discipline of forming strong sentences begins with slowing down. Fast speech is almost always the enemy of clear sentences because speed allows the speaker to outrun their own thinking. When you slow down, genuinely slow down, in a way that may feel uncomfortable at first, you give your mind time to construct the sentence before it leaves your mouth. You give yourself the luxury of choosing the word that actually fits rather than accepting the first word that arrives. You also give your listener time to receive what you are saying. A sentence that is spoken clearly and deliberately at a measured pace does not need to be repeated. It lands, it registers, it is understood. And an idea that is understood has already done most of the persuasive work on its own. Remove the fillers. Every every basically and like is not just an auditory inconvenience. It is a signal to the listener and to yourself that the sentence was not ready to be spoken. Fillers are the verbal equivalent of showing up to an argument without having read the file. They announce hesitation, they invite doubt, and they are entirely avoidable if you give yourself permission to think before you speak, even if the silence feels long. The most powerful sentences are often the simplest ones. Not simplistic, simple. There is a profound difference. Simple sentences carry complex ideas in clear language. Simplistic sentences carry shallow ideas in easy language. What we are after is always the former, the complex thought, stripped of all unnecessary dressing, delivered directly. 2. Tone and pace are not accessories, they are the argument. You can write the perfect sentence and still lose the room if you deliver it wrong. Tone and pace are not supplemental to your message, they are inseparable from it. The same words spoken in a rushed voice with a rising inflection carry a completely different weight than those same words spoken slowly, at a steady pitch, with a downward conclusion. One version asks for permission, the other states a fact. Juries, opponents, and audiences respond to these differences with remarkable consistency, often without being consciously aware of what they are responding to. The controlled voice is not a monotone voice. Let me be precise about this because the mistake is common. Control does not mean flatness, it means intention. It means that every variation in your pitch, your volume, your speed, every rise and fall is a choice, not a reflex. Lawyers who are truly powerful in their delivery do not eliminate emotion from their voice. They direct it. They know when to let conviction enter their tone and when to retreat to calm, factual authority. They know that urgency, when well placed, is persuasive, but urgency that appears at every sentence is indistinguishable from panic. Pace is a form of respect. When you speak too quickly, you are implicitly telling your listener that catching up is their problem, not yours. When you speak at a pace that allows comprehension, you are telling them that you care about being understood, and people respond to that care with attention and trust. Pace also gives your own thinking room to breathe. Speakers who rush their delivery often find themselves painted into rhetorical corners, halfway through a sentence whose ending they have not yet located. Slow down, and the sentence tends to take care of itself. The pause deserves its own full treatment, and it will receive it. But as it relates to tone and pace, understand this. A pause in the middle of a controlled delivery is an event. It is not an accident. It signals to the listener that something important is arriving or has just arrived, and it gives that moment the emphasis that no adjective or raised voice could provide. Learn to treat silence as a tool, not as a failure of speech, but as speech itself, operating at a frequency your words cannot reach. 3. Vocabulary is precision, not performance. There is a persistent and damaging myth that impressive vocabulary means using the most complex word available at any given moment. This myth causes people to reach for obscure terms when common ones would serve better, to prefer the Latinate over the plain, the technical over the accessible, and in doing so, to make their communication simultaneously more difficult and less effective. Lawyers who genuinely command language know the opposite truth. Vocabulary is not about complexity, it is about precision. The goal is to find the word that fits the idea most exactly, not the word that sounds most impressive, but the word that communicates most accurately. When these two qualities coincide, so much the better, but when they conflict, precision wins, every time. Consider the difference between I think and I believe. Both are short, both are common, but I believe carries with it a stronger assertion of conviction, a suggestion that what follows is not a passing impression but a considered position. Lawyers choose between these deliberately. Consider the difference between important and essential, between uncertain and ambiguous, between said and stated. These are not dramatic differences in vocabulary level, they are differences in precision, and precision accumulates. Over the course of an argument or a conversation, speakers who consistently choose the more precise word sound categorically different from those who reach for whatever is closest. Build vocabulary the way you build any skill, through exposure and through practice. Read broadly and read deeply. Read things that challenge your language. Not everything needs to be legal text. In fact, some of the finest models of precision in English prose come from writers who never argued a case in their lives. The point is to encounter words in the context of ideas, which is the only context in which they can be truly understood and retained. When you find a word that is new to you, do not merely learn its definition. Understand its connotation. Understand what company it keeps, what other words it tends to appear near, what kind of argument or idea it tends to serve. Then use it. Speak it aloud. Use it again in a different context. Vocabulary that you can recognize but cannot produce is a library whose books you cannot open. The words must come to you when you are speaking under pressure, without time to consult anything but your own internalized command of language. And as you build your vocabulary, begin also to prune it. Remove the imprecise, retire the vague. Stop accepting good when you mean sound. Stop accepting bad when you mean untenable. The goal is always the right word, and the right word is almost always already within your reach. It simply requires you to reach for it instead of accepting the first approximation your mind produces. 4. Logic is your foundation, not your constraint. The courtroom is not governed by emotion. Neither is any other environment where the stakes are high and the outcome genuinely matters. Boardrooms, negotiations, academic defenses, policy debates, these are spaces where the currency is reasoning and where emotional appeals, unless they are grounded in something demonstrable, tend to reduce rather than increase a speaker's credibility. This is one of the most important habits a developing communicator can cultivate, the discipline of logic. And I want to be clear about what I mean because logic can sound cold, and cold communication is not what we are after. I mean the habit of organizing your thoughts before you speak. I mean the practice of connecting your statements with reasoning that your listener can follow. I mean the commitment to knowing, before you open your mouth, not just what you want to say, but why it is true and how you know it. Lawyers structure arguments in sequence because sequence makes thinking visible. When you say first, your listener knows there is a second coming. When you say therefore, they know a conclusion has been drawn, and they can evaluate whether the preceding reasoning supports it. These transitional markers are not just stylistic, they are logical signposts. They demonstrate that your ideas are connected, that there is a through line running from your premise to your conclusion, and that you have checked whether it holds. The discipline of logic also protects you from your own enthusiasm. It is very easy, particularly when speaking on topics you care about, to move faster than your reasoning can actually carry you. Emotional momentum pushes speakers forward. Logical discipline holds them to account. When you require yourself to state not just your conclusion but your reasoning, when you require each claim to be supported before you advance to the next one, you build arguments that are genuinely difficult to dismantle. You build positions that hold up under scrutiny. You sound, in the fullest sense of the word, credible. And credibility, once established, compounds. A listener who has trusted your reasoning through the first part of your argument is primed to trust it through the second part. A speaker who has demonstrated logical coherence earns the benefit of the doubt in moments of ambiguity. This is not manipulation. It is the natural consequence of having shown, through your words, that you think carefully. 5. Questions are not requests. They are instruments. A question is one of the most powerful tools in a communicator's arsenal, and it is almost universally underused. Most people ask questions when they do not know something. Lawyers ask questions to do a dozen different things at once: to guide, to reveal, to challenge, to clarify, to establish common ground, to expose contradiction, to draw a reluctant listener through a chain of reasoning they might resist if it were presented as assertion. The art of using questions is the art of understanding that a question controls a conversation without seeming to. It directs attention. It shapes what the other person considers. It creates intellectual space for conclusions to emerge rather than forcing them in from the outside. When you ask, "Can you explain what you mean by that?" you are doing several things simultaneously. You are demonstrating that you are listening carefully enough to have noticed something that requires clarification. You are showing that you are not content with vague language, that you hold both yourself and your interlocutor to a standard of precision. You are also, importantly, taking some pressure off the conversation. You are not challenging a statement. You are inviting it to be developed. This tends to produce more honest and more useful responses than a direct challenge would. Evidence-based questions are particularly powerful. What supports that conclusion? Where does that information come from? Is there data that would change your position on this? These questions are not aggressive. Properly delivered, in a tone of genuine inquiry rather than prosecutorial challenge, they are among the most collegial questions you can ask because they take the other person's position seriously enough to want to understand its foundations. They also have the practical effect of distinguishing between claims that are well-grounded and claims that are not, which is information that nearly every productive conversation needs. The exploratory question opens minds rather than closing them. Have you considered the possibility that, what would the alternative look like? If we approach this from a different angle, where would that take us? These questions invite the conversation to grow. They demonstrate intellectual generosity. They position the person asking them as a thinker rather than an advocate, or rather as the most effective kind of advocate, one who has genuinely considered all the available ground before choosing where to stand. Develop the habit of the smart question. Resist the temptation to respond immediately to everything with a statement of your own view. Often, a well-chosen question will serve your purpose better than any assertion, and it will do so in a way that leaves the other person feeling heard rather than challenged. 6. Your body has already spoken before you do. The moment you enter a room, you have begun communicating. Before a word has left your mouth, before a question has been answered or a position stated, the people in that room have already formed an impression. They have assessed your posture, your movement, your gaze, your presence. They have decided at some preconscious level whether to grant you authority or withhold it. And these decisions are extraordinarily difficult to reverse once they have been made. This is not superficial. It is neurological. Human beings are wired to read physical signals with extraordinary speed and sophistication, far faster than we process verbal information. A legal argument can be technically brilliant and factually airtight, and it can still fail to land because the person delivering it communicated with their body that they were uncertain or anxious or not quite sure they deserved the room's attention. Posture is not vanity, it is expression. When you stand with your weight balanced, your shoulders open and slightly back, your head level, not chin raised in aggression but not lowered in apology, you are communicating something before you have spoken a syllable. You are communicating readiness, presence, the quiet confidence of someone who has prepared and knows it. Eye contact is perhaps the most powerful of all physical signals. It is the difference between speaking to a room and speaking with the people in it. When you hold someone's gaze, not in a fixed stare, but in the natural, interested way of someone who is genuinely attending to another human being, you create a connection that no amount of rhetorical brilliance can manufacture from behind a downcast glance. Eye contact says, "I am here. I am not afraid. I believe in what I am telling you." Gesture should serve your words, not decorate them. Intentional movement of the hands can emphasize, can illustrate, can invite. Nervous movement, the tapping, the fidgeting, the unconscious self-touching, does the opposite. It signals that something inside is unresolved. It pulls your listener's attention away from your words and toward your anxiety. Still hands, until you have something specific for them to do, are almost always the right choice. 7. The pause is the argument. I want to spend more time here than the topic might seem to warrant, because the pause is the most consistently undervalued tool in communication, and because mastering it will change the way you speak more dramatically than almost anything else I could tell you. Silence is not the absence of communication. Properly deployed, it is the most intense form of it. When you pause after making a critical point, you are doing something that no word can do. You are giving that point room to exist in the consciousness of your listener. You are saying, without saying anything, consider this. Let it settle. Do not be in a hurry to move past it. The point deserves to stand for a moment unaccompanied before the next idea arrives to compete for attention. This is how emphasis is created, not through volume, not through repetition, not through increasingly dramatic adjectives, but through silence. The pause turns a sentence into an event. The pause before a critical statement creates anticipation. It signals to the listener that something important is coming. It creates a small but genuine tension, and in resolving that tension, it delivers the statement with a force that normal pacing cannot achieve. Trial lawyers have understood this for generations. The well-placed pause is not a hesitation, it is the opposite. It is a demonstration that the speaker is in complete control of the timing of their own communication. Pauses also give you something that speakers in full rhetorical flight often lose: time to think. When you allow yourself to pause between ideas, you do not have to plan your next sentence while simultaneously delivering your current one. You can speak to completion, stop, think deliberately, and then speak again. This produces better sentences, it produces better arguments, and it produces a speaker who sounds, paradoxically, far more confident than one who speaks without interruption, because the continuous speaker is often running from silence, and running from silence is indistinguishable, to a careful observer, from running from doubt. Let me be direct with you. The pauses that feel longest to the speaker are rarely long at all to the listener. What feels like an eternity of uncomfortable silence from inside your own head is often, from the outside, a thoughtful and confident beat. The natural rhythm of someone who cares about the quality of what they are saying. Give yourself permission to pause. Give yourself permission to be silent for a moment. Nothing in that silence will be held against you. What will be noticed and remembered is the authority of the words that follow. 8. Precision and facts. The only armor that holds vague language is a liability. It invites misinterpretation. It projects uncertainty. And in high-stakes communication, in any communication where the outcome genuinely matters, it tends to collapse under the slightest examination. Lawyers learn early that imprecision is not merely an aesthetic failure, it is a strategic one. When you say, "many people believe," without specifying who, you have made a claim that cannot be verified, challenged, or properly weighed. When you say, "the evidence suggests," without identifying the evidence, you have offered the appearance of factual grounding without its substance. These constructions may feel safer than specific claims. They seem to leave room for retreat, but in practice they create the impression of someone who has not done the work or who does not quite believe their own position. Precision means saying specifically what you mean. It means when you cite evidence, citing it by name. It means when you draw a conclusion, stating it as a conclusion rather than a suggestion. It means when you do not know something, saying you do not know because I don't know, but here is what the evidence does tell us, is infinitely more credible than a vague gesture toward unspecified support. Being factual does not mean being cold. It does not mean reducing human situations to data points. It means grounding your claims in something verifiable, in something your listener can check in principle, even if they never do. There is a kind of authority that comes from speaking in facts, from preferring the concrete to the abstract, from being willing to name your sources and stand behind your citations. This authority is available to anyone willing to do the preparation that precision requires. Equally important is the avoidance of overstatement. Always and never are extraordinarily dangerous words in serious communication because a single counterexample defeats them entirely. typically, and in the vast majority of cases, are far harder to disprove and are usually closer to the truth. The speaker who states only what they can actually defend is not a cautious speaker, they are a credible one. And credibility is what you are building with every precise, factual sentence you deliver. 9. Purpose is the first word and the last. We come now to the ninth principle, and it is the one from which all the others derive their meaning. Everything we have discussed, the clean sentences, the controlled pace, the precise vocabulary, the logical structure, the smart questions, the confident posture, the intentional pauses, the factual precision, all of it is in service of this, speaking with purpose. Purpose is not just a direction, it is a commitment. It is the decision, made before you open your mouth, that every word you speak will be working towards something specific, not toward the general goal of sounding good, not toward the social goal of filling silence, not toward the anxious goal of demonstrating that you are prepared, toward something specific, a conclusion you want your listener to reach, an understanding you want to create, a decision you want to make possible. Lawyers do not speak into rooms the way water runs downhill, following the path of least resistance. They speak into rooms the way architects design buildings, with a clear sense of the structure they are constructing, the materials they are using, and the experience they want their audience to have when the structure is complete. Every sentence is placed deliberately. Every transition is chosen. Every moment of silence is earned. When you know why you are speaking, not just what you are going to say, but what you want your words to accomplish, your language becomes more disciplined without effort. You stop reaching for words that simply fill space and start reaching for words that actually do work. You stop including ideas because they feel related and start including only ideas that genuinely serve your purpose. You become a speaker who uses language the way a skilled trial lawyer uses every minute of closing argument. Not a word wasted, not a moment unintended. Purpose also transforms the way you listen, because purposeful speakers understand that communication is not a monologue. They listen to determine whether their message is landing. They adjust based on what they hear. They ask questions because understanding the other perspective helps them serve their purpose more effectively. Purpose-driven communication is dynamic, responsive, and always oriented toward the outcome that matters. 9 principles. None of them require a law degree. All of them require practice, attention, and the willingness to hold yourself to a higher standard than most people apply to their daily communication. Clear sentences, controlled tone and pace, precise vocabulary, logical structure, smart questions, confident body language, the deliberate pause, factual precision, and purpose, always purpose, running through everything like a current. These are not the habits of a particular profession. They are the habits of any person who takes seriously the possibility that their words can matter, that what they say and how they say it can actually change the outcome of a conversation, a room, a situation. I have spent my career believing this, and I have seen it proven correct more times than I can count. But here is what I want to leave you with, because it matters beyond the courtroom. The lawyer who speaks this way also earns more trust, builds stronger relationships, leads more effectively, and contributes more meaningfully to every conversation they enter. Not because they dominate those conversations, but because they elevate them. They bring a level of care and intention to language that is increasingly rare, and that rarity makes it increasingly powerful. You do not need a courtroom to develop this. You need a commitment to practice, to slowing down, to choosing your words more carefully, to listening more attentively, to taking the preparation seriously that most speakers skip. You need the discipline to pause when the filler word is rising in your throat, to think for an extra beat before the sentence begins, to ask the smart question instead of offering the easy answer. Do this consistently, not for a week, not until it becomes slightly more comfortable, until it becomes who you are as a communicator, until the purposeful sentence is your default rather than your effort, until the pause is natural and the precise word arrives without a search. That is when you will know you have internalized something real, not just a set of techniques, a way of thinking about language and what it is for. That is when you will speak like a lawyer.